Good evening. Thanks so much for joining us tonight for this next live Google Hangout by Americans for Safe Access. My name is Don Duncan. I'm the California director, and we're here to talk tonight about medical cannabis in California, new regulations, legalization, and what comes next in the state of California. So thanks again for joining us. A little bit of an outline of what we're going to cover tonight. We're going to talk about the Medical Marijuana Regulation and Safety Act here in California. That's the title that's given to 3 bills recently signed by the governor. We're going to talk about legalization in California because I know that's on a lot of people's minds and what that means for medical cannabis. And then we're going to talk about what happens next year in the state of California. And so I want you guys to tune in, finish installing that software if you need to. And remember, if you're having trouble on Google+, you can always go to YouTube. And so I want to remind everyone that whether you're joining us on Google+ or on YouTube, in the comments section, you're going to find some links from me. You're going to find links to blogs that I've published on this topic, and also to some really great analysis by medical cannabis expert Steve LaBelle from Los Angeles. He's an attorney and an advocate in Los Angeles, and many other resources there. So have a look at the comments section, which will also include important comments from other people like you who are watching this broadcast right now. I plan to speak for about 30 minutes or less, and then we're going to have a time for questions or comments. We've left about an hour for this whole broadcast, and how long we go depends on how many comments or questions you guys have. So get ready. We're not going to take them yet, but Talana is standing by in our DC office, and she's going to be sending your questions out to me. So wait just a minute before you start typing, and I'll let you know as we move forward with this live broadcast when it's time to start typing in those questions. There's only about this much room on my screen for questions, so I need those to come in one at a time, please. So again, thanks for joining us. If you're just now logging on, this is the live Google Hangout about medical cannabis in California, regulations, legalization, and more. And so we're going to get started tonight talking about what I think most of you are concerned about and curious about, and that is the Medical Marijuana Regulation and Safety Act, MCRSA. And that terrible acronym, if you didn't spell it out yet, it's the same as a deadly virus, MRSA. But the Medical Marijuana Regulation and Safety Act was signed by Governor Jerry Brown on the 11th, on October 11th of this month. And so just a few days ago, but since it's been signed, we've seen really an amazing shift in the media coverage of this issue and also in the local politics in the state of California. When last we were doing one of these broadcasts, I think I used the phrase a golden era for local regulation in California. And while that may be still a bit of a hyperbole, I am really encouraged to see all over the state of California, local governments are moving now or preparing to move towards local regulation and licensing of medical cannabis. And that is exactly what we hoped we would see when the statewide licensing and regulations were approved. And so I'm really happy to see that even in a few days since the governor signed this bill and months before it becomes effective, we're already seeing local jurisdictions moving. Jurisdictions like Humboldt, Palm Springs, even in Los Angeles to a certain degree, they're moving towards regulation, and many others that we're seeing around the state. If you want to keep tabs on that, be sure that you're receiving my California Weekly Roundup, where I send you all the news from all over the state of California. If you're on the ASA mailing list, go to safeaccessnow.org and get on that list. You'll get those weekly updates that talk to you about state and local politics and medical cannabis. So I'm really, really happy to see that, in fact, as the news of the state regulations, the overwhelmingly positive news in the news media percolates around the state, cities and counties are responding to this new state licensing and regulation by moving towards local regulations. We're going to talk about why that's important in just a minute. But first, let me give a recap of the Medical Marijuana Regulation and Safety Act, which is actually 3 bills. 3 bills comprise this act. They are AB 243 by Assemblymember Wood, AB 266 by Assemblymember Cooley, and SB 643 by Senator McGuire. These 3 bills come from all over the state of California, and they have bipartisan support. And so what the MMRSA did is well, first of all, most importantly, it preserved every single right that was guaranteed to patients and primary caregivers under Proposition 215, which is really, really important because in other states, we've seen the rights of medical cannabis patients eroded, and we'll also revisit that at the end of this broadcast as well. Now, some of you are thinking right now, what about the cultivation limits? And it is true that there's been an infringement at the 11th hour on the right of patients to cultivate. I'm going to get back to that unfortunate development a little bit later, but on the whole, these bills respect all of the rights under Proposition 215. So what does the MMRSA do? I'm speaking here about all three bills collectively. And so the first thing you should know is that it makes unprofessional conduct related to recommending medical cannabis by a physician a higher priority for enforcement by the medical board. What that means is that if a doctor is not keeping records or otherwise behaving in the way that we traditionally expect doctors to be, that can be a higher priority for the medical board. I'm not frankly very concerned about this provision because while we do want doctors to uphold the highest possible standards when they give medical marijuana recommendations, the medical board has been very reluctant to actually move and prosecute and punish doctors for medical marijuana offenses. Not that it doesn't happen. There have been notable cases, but there has not been a wholesale witch hunt against doctors. There is an important proviso here, and that is that some people are concerned that the MMRSA requires that you get a medical marijuana recommendation from your primary care physician. That is not in the law. That is an often misquoted aspect of this law. What it says is that a medical marijuana recommendation should come from your attending physician as defined in the Medical Marijuana Program Act, that is SB 420. And so an attending physician is simply someone who does a good faith prior exam and gives you a medical marijuana recommendation for an actual medical condition. And frankly, I don't think that's too much to ask from doctors. That is really a very basic standard of care in the state of California. And so I don't think we're going to see doctors unduly burdened by the need to actually perform an exam of their patients or their medical records and to write a recommendation for a specific condition from which that patient is suffering. That's frankly an acceptable provision in these laws. And so that's the gist of it around doctors. Now, the MMRSA also prohibits doctors from taking kickbacks from dispensaries. And I think most reasonable patients would agree that that's actually a good thing. When a doctor is writing a recommendation, whether it be for medical cannabis or any other treatment, we want that recommendation to be based on the needs of the patient and not on the financial interest of the doctor. And so it is a crime under this bill for a doctor to have a financial relationship with a medical cannabis dispensary that could cloud his or her judgment in terms of whether or not to recommend medical cannabis. Again, I do not think that's going to be a problem for patients seeking legitimate medical cannabis recommendations. So what else does the MMRSA do? Well, the first thing you should know is it creates for the first time in California a legal framework for medical cannabis licensing and regulation in the state of California. It's been 19 years now since voters approved medical marijuana. They adopted Proposition 215, known as the Compassionate Use Act. And that was a huge step forward. And we can't say how important that is in the history of medical cannabis. And yet that act called on lawmakers to adopt a plan for safe and affordable access to medical cannabis for people who need it. And it's been 19 years that the state legislature has struggled to do that. And so MMRSA actually represents the fulfillment of the mandate of the voters in Proposition 215 to actually adopt a legal framework for medical cannabis patients. And it's really important because the implementation around California has been a patchwork of local regulations, some that are very permissive, some that are very restrictive, some that are outright bans, and others that are simply silent on the issue of medical cannabis. And so finally, we're moving to an era in California politics where we can have some consistency and some stability for safe access for the broad majority of people in California. Perhaps not everybody, as we're going to discuss in a minute, but a broad majority of the people in the state of California. The MMRSA protects workers and officers and business owners who are involved in the medical cannabis industry for the first time. The legal protection for people in the medical cannabis industry has been implied for some time. That is, our cooperative and collective defense implied under the Medical Marijuana Program Act, or SB 420, has always been open to interpretation in the court. And the MMRSA for the first time says that if you're an employee, an officer, a director, or an owner of a legal medical marijuana business, you are not breaking the law in California. And that is an unprecedented level of protection for people involved in the industry. So I'm really, really happy to see that in this bill. It's something that many, many advocates fought really, really hard for. The other thing that's important to know up front is that the MMRSA brings the state of California into compliance with a U.S. Department of Justice memo outlining priorities for enforcement of federal law. And one of the important priorities in the memo published by Deputy U.S. Attorney Cole says that a state needs to have a robust and well-enforced medical marijuana regulatory framework. And for the first time in California, we can say we do have a robust and effective regulatory framework at the state level. And so assuming we can take the feds at their word, and I know that's not a given, but assuming we can, and assuming we don't have a change in federal policy with the next presidential election, we will be properly positioned with other states that have state licensing and regulatory schemes that are not seeing federal interference and intimidation right now. So those are some really, really big things to consider about the MMRSA. There's some other things that this bill does in advance. And I should say that one thing it does is it sets up a viable framework that will work with legalization in 2016. And this is really important because it's probably the case that voters in California are going to vote on legalizing cannabis for non-medical adult use in 2016. And MMRSA is the first state proposal in California that actually anticipates that and sets up a reasonable framework for regulating both medical and non-medical use of cannabis. And so that's a big step forward. So let's talk for a moment about what specifically the MMRSA does. It creates the Bureau of Medical Marijuana Regulation within the Department of Consumer Affairs. And this new bureau is charged with overseeing the licensing and the regulation of medical cannabis on a statewide basis, most importantly in the area of cultivation. And so this new bureau in DCA will be sort of the head agency for regulating medical cannabis in California. There's a very complicated framework for appointing the various members of the bureau. The director will be appointed by the governor. Other state officials will appoint other, and committees will appoint other people to the bureau. And this bureau will sort of preside over regulations in California. That's really important because we're not putting regulation, say, in the Department of Alcoholic Beverage Control, where cannabis will be treated like a vice, like alcohol or tobacco. It's in the Department of Consumer Affairs. And DCA has within its mission consumer protection and licensing to make access possible for other kinds of services and products. And so DCA is really the place where regulation should be. The Department of Food and Agriculture will assist in developing regulations for medical cannabis cultivation. The Department of Health will create regulations for manufacturing, testing, and labeling of edible products. And the Departments of Public Health will deal with testing and labeling of preparations. We've got the Department of Fish, Wildlife, Department of Pesticide and Regulations, and the State Water Board that will all be dealing with consumer and environmental protection related to medical cannabis cultivation and production. And so that is really an alphabet soup, frankly, of state agencies. What I like about this regimen, even though it's complicated, is that all of the various areas of regulation for medical cannabis are put in the appropriate state agency. Food and Agriculture for cultivation, Department of Consumer Affairs for public safety, and the other relative agencies. And so even though it's complicated, it's fundamentally appropriate that these various agencies will be overseeing medical cannabis regulation in the state of California. So this process creates 17 different kinds of licenses. And there are so many licenses because the Bureau seeks to accommodate players at different levels of the medical cannabis industry: small cultivation, medium cultivation, large cultivation, small dispensary, medium dispensary, large dispensary, and so on. And so we're making a space here, including sliding scales and different levels of regulation for different sizes of players in the medical cannabis industry. And that's really important in California because California is unique in that here in California, we're not creating an industry from the ground up. The industry already exists. There are already people who know how to cultivate, manufacture, transport, and provide medical cannabis. And so we need to make a space for all the players in that industry. And so this sort of tiered licensing and scalable fees is really, really an important process, an important victory in the process for medical cannabis patients and their providers right now. And so these 17 different licenses are confusing, but ultimately they're very, very appropriate for what's happening in California. Excuse me. There's a new license in California, a new type of business created under the MMRSA, and that is the medical cannabis distributor. Now, you might be thinking that a distributor is a transporter. It's actually not the same thing. This is a distributor in the same way that we have distributors in alcohol and tobacco. And this is a business that is charged with facilitating in California inventory control and taxation of medical cannabis. It's the same process they use in alcohol and tobacco to make sure that cultivators and distributors, cultivators and manufacturers and retailers have an accountability within the process. And so medical cannabis distributors will be counting, labeling, testing, and taxing medical cannabis in the state of California. I frankly don't think we needed to go to that level, but we did. And the industry will adapt, and we will have many medical cannabis distributors in the state of California who will process cannabis and make it available to the various parts of industry down the stream, from the cultivators to the manufacturers who turn cannabis into various products, to the retailers who actually provide it to the patients who need that medicine. So the distributor model is a new thing and something we can ultimately deal with in the state of California. So the bill also requires that every medical cannabis business obtain a state license, permit, or approval for providing medical cannabis in California. This has been a really controversial topic because many cities and counties are silent on medical cannabis. They don't give a license, a permit, or an approval, and some have banned medical cannabis activity outright, whether that be distribution or cultivation. And so this is going to be a hurdle for some places in the state, and I'm afraid for some they'll never get over it. And I want you to know that ASA fought hard to get rid of local control in these regulations, but the politics of California are much bigger than medical cannabis, and local control is a deeply enshrined value of the state of California. Cities and counties have very broad latitude historically here to determine what and how businesses do and operate within their borders. And so medical cannabis was pushing against the trend in trying to prevent cities and counties from prohibiting medical cannabis activity. There was a Supreme Court case about 18 months ago, Riverside versus Inland Empire Patients Wellness Center, that established that nothing in state law prohibited cities and counties from banning dispensaries. The same basic principle probably applies to medical cannabis cultivation. However, the jury's still out on that. I know there are pending lawsuits, and one of the biggest victories that we scored in this process regarding local control is that this bill, the MMRSA, is silent on local bans. You may have heard on the internet already that the MMRSA authorizes cities and counties to ban medical cannabis activity. That is absolutely wrong. What it does is it remains silent. It doesn't say they can, and it doesn't say they can't. And so any legal challenge that's currently pending, or any future challenge that's possible regarding bans on dispensaries or cultivation, that's still on the table. This bill does not stop anyone from pursuing this issue in the courts. Whether or not they're successful, frankly, I have a lot of doubts about that. But I wish all of the plaintiffs and potential plaintiffs the best of luck, and I want to encourage you to keep fighting, because nothing in the MMRSA stops you from pursuing your rights in court as a citizen and as a patient in California. So let's talk a little bit about the process of the MMRSA. These were 3 bills. Americans for Safe Access supported 2 of them. We opposed 1. And our strategy all along has been to come to the table and to negotiate, because we know that regulations are coming, that they were at some level inevitable, and we had to be at the table to be effective and influential. This strategy is important because up until recently, there's been a situation in California where law enforcement and local government have stood on one side of the divide and said there will be no regulations for medical cannabis in California. And advocates and industry have stood on the other side and said, no, we need reasonable regulations. And there was really no breaching that gulf until a couple of years ago. In 2012, Assemblymember Amiano proposed AB 2312, a bill that would have regulated medical marijuana to the benefit of the medical cannabis industry, and I think patients as well. And while that bill failed, it was a shot across the bow of law enforcement and local government, and they knew they had to come to the table. And I think one of the greatest victories for the cause of medical cannabis was that last year, the California League of Cities and the California Narcotics Officers Association and other law enforcement lobbyists were forced to come to the table and for the first time talk about medical cannabis. We worked on a bill last year called SB 1262 by Senator Correa. That bill was ultimately not successful, but it was a milestone because it was the first time law enforcement, cities, advocates, and industry all sat down at the table together and started to breach our differences. And this year, we're really reaping the fruits of those efforts because with the new bills, AB 243, AB 266, and SB 643, we're seeing an unprecedented degree of participation, cooperation, and accommodation. And while not everything of the bill in the bills is perfect and not everything is what we want, we really took some questionable or even bad proposals and made them way better. And I have to say, even the bill we opposed, which is AB 243 by Assemblymember Wood. We opposed it because of taxation and other provisions. Even that bill ended up way better than where we started. And so I want to suggest to you that this strategy of engagement, compromise, pragmatism, and working in the system to get what we all want worked this year. And we got a pretty good bill. And while I know there are many people in California who don't want regulations, or at least fear regulations, there are many more who are going to benefit and believe that we can move forward down this path. And so I'm really excited about the MMRSA and the victories we won in this process. I'm going to highlight a few of those before I talk about what it is that we need to do differently next year and what our process is for changing some of the things we don't like in this bill. The first and foremost thing I want to point out as a victory is that patients and primary caregivers are exempt from licensing and regulation in this bill, with one proviso that we're going to just discuss in just a minute. But on the whole, we stopped the situation that happened in the state of Washington where patients had to give up their rights in order to accommodate the industry. Medical cannabis patients in California have preserved almost every single right they had prior to regulation, and I'm confident we're going to get back that last little space we gave up. Personal cultivation is protected, unlike we saw in Washington and other states. If you're a patient or a primary caregiver, you can still grow your own cannabis. This is crucially important for self-sufficiency, for economics, for preserving biodiversity, for cultivating strains that service in each market of patients. It's really important we preserve this. And I want you to know ASA will never support a bill in California or anywhere else that forbids patients to grow their own medicine. That is not on the table. A big victory that we also won is that, as I mentioned before, the bill is silent on issues of bans on dispensaries and cultivation. We're going to talk about some victories about that at the end of this section. The bill puts oversight in the Department of Consumer Affairs, which is charged with consumer protection and licensing and ordinary regulation, as opposed to the Department of Alcoholic Beverage Control. The Department of Alcoholic Beverage Control is staffed by deputized peace officers, essentially policemen, who are charged with restricting the access to alcohol and prosecuting and enforcing those prohibitions. That is not how medicine is regulated. There's no other medicine in the state of California that is regulated by police officers charged with keeping that substance from the consumers. We do not want the regulation of cannabis in the Department of Alcoholic Beverage Control. It belongs where consumer protection and licensing is part of the mission, and that is Department of Consumer Affairs. For many people, that was a silent victory because you didn't see that unfolding, but all the way back to 2012, ASA has, at times, been the sole voice opposing regulating cannabis like a vice. And I'm very proud of the fact that we stuck to it, even when allies and some supporters and our donors said, don't fight this battle. We stuck to it and we kept cannabis out of alcohol regulation. And I think that's a huge benefit for patients in California. Finally, the bill also allows, not finally rather, but second to last, the bill allows for delivery of cannabis anywhere in the state of California unless it's specifically banned. The significance of that is this. Our opponents tried to insert into this bill a provision at the last minute that would have required cities and counties to specifically approve of the delivery of medical marijuana. So legal dispensaries would not have been allowed to deliver medical marijuana in any city and county that did not specifically pass an ordinance authorizing that delivery. That would have restricted access in vast swaths of the state. And we pushed back. We pushed back and said, no, delivery shouldn't be allowed anywhere. And if you have to have a restriction on delivery, it should be only disallowed where a city or a county has banned that activity. And we won that battle. I'm really proud of that victory too, because what that means is that the majority of patients who live in jurisdictions that are silent on medical cannabis right now still have access to delivery from licensed medical cannabis providers in California anywhere in the state. And so the hundreds of licensed facilities that will be open when the bill is effective can still provide medicine to any legal patient in the state of California, unless that patient lives in a city or a county that is misguided and mean-spirited enough to actually ban delivery. And if you live in a city or county like that, first of all, vote them out of office, because that is an absolutely ridiculous restriction on safe access to medical cannabis. And secondly, there's probably someplace just outside city limits where you can meet the delivery person. Work that out, because there's no need for anyone in California to be without their medical cannabis. Also, coming to the end here, there is no statewide tax on cultivation mandated in this bill. One of the bills, AB 243 by Assemblymember Wood have imposed at first a $50 per plant tax on medical cannabis. Later, they went back and said, oh, we're going to have some kind of a tax on square footage of cultivation, but we don't know what it is. And in fact, the bill that went to lawmakers after the final committee hearings actually had a blank space in the bill for the tax. So we don't even know what the final tax per square foot might have been. But the fact is this: in a legal regulated market in California, those people participating in the commercial market, the cultivators, manufacturers, distributors, and retailers, they're going to pay fees that pay for the cost of implementation and should pay for the cost of environmental enforcement when it comes to remediation associated with outdoor cultivation or even for indoor cultivation. There's no need in California for a sin tax on medical cannabis cultivation. ASA stood up as one of only a handful of voices in the state of California, and we opposed the sin tax on medical cannabis cultivation, and we won that battle. Now, it's not over. It's back on the radar for next year. But as of right now, there is no statewide tax mandated in the Medical Marijuana Regulation and Safety Act. So that's a big victory for patients, and I hope you appreciate how important that is, because these regulations may increase cost for patients on the short term. I believe on the long term they won't. But a statewide tax does not respond to market forces. No matter how efficient the industry is, no matter how smoothly regulations go, that statewide tax was always going to be a burden on patients. And it's so important that it was defeated, because we do not tolerate sin taxes on medicine. You can put sin taxes on vices, you can put sin taxes on luxury goods, but you do not put a sin tax on medicine that patients need. And I'm really proud of the fact that we stood up, we fought back, and we pushed back on that excise tax, and it's gone as of now. But we have to keep fighting, because there's already a bill on the table for next year that will put that back in place. And so we need to keep fighting on that sin tax issue. So those are some really important victories we won. And had we taken the strategy of saying, we're not going to engage this year, we're going to stand back and oppose regulations and defend the status quo, we would not have won those victories. And so I'm really proud of both where we started and where we finish with this bill. I want to finish this section of our broadcast by talking about this local control issue, because it's still one that sticks in the craw of many patients, because there are places in California where medical cannabis is not a reality yet, and Proposition 215 is still largely hypothetical. And that's a really big problem. And we couldn't fix that this year. We couldn't fix it with state legislation. We haven't been able to fix it in the courts. And so we're going to have to chip away with it over the years. And I think that we've made a big step, because I know many cities and counties that were ambivalent are going to be more comfortable moving forward with local licensing, authorization, or permitting of medical cannabis now that there's a state law on the books. In some places they won't, and it's going to fall to local activists to deal with that. We'll get to that in a minute. But before I talk about that, I want to talk about the important victories we won on this long, long battle for local control. And first and foremost, we won a concession for those jurisdictions that don't say anything about medical cannabis cultivation. If your city or your county does not ban cultivation or does not license it, and they have a zoning code that is permissive in nature, then I'm sorry, I should say that phrase permissive is funny in local jurisdictions. If your zoning code, I should say, does not require approval for that activity, then the state can move ahead with licensing cultivation in that jurisdiction. So we don't know yet how many jurisdictions fall into that category of having no regulation or ban, and also having a zoning code that does not forbid any non-specified activity like medical cannabis cultivation. I don't think it's many, but I think the number that are there are really significant. If you're in one of those jurisdictions, the state can license commercial cultivators in that jurisdiction without local approval. That's a really important step towards universal licensing of medical cannabis. Secondly, the authors agreed to allow the word approval in addition to licensing and regulation. We don't know what approval means. Approval could be a letter from your city council, your county board of supervisors, or it could be some preponderance of evidence that shows that you're operating in compliance with local laws. We don't know yet. The bureau that's established by these bills will figure that out, but it's going to open up more jurisdictions in California than there would have been without the word approval in this bill. And finally, the provisions of the bill that require local licensing as a prerequisite for state licensing do not take effect until 2018. So you have 2 years to get busy in your city or your county and adopt an ordinance that provides for local licensing, approval, or permitting of medical cannabis activity. And so Americans for Safe Access has launched a new program to help you do that. We're going to be rolling it out in several stages this fall. It's called the Local Access Project. If you go to our website, americansforsafeaccess.org, you'll type americansforsafeaccess.org/local_access_project. Local Access Project, and you'll find in our California Campaign for Safe Access resources and information for people who want to adopt local ordinances to authorize the medical cannabis cultivation, manufacturing, transportation, distributors, retailing, testing, all of this activity. All of that you can license and permit at your local level. And I know there are some cities and counties, I'm not going to name them because I don't want to jinx it, but I do know there are jurisdictions in the state that will never do this. And that's a damn shame. But there are many that will do it that haven't. And it falls to local activists, advocates in cities and counties all over the state of California to make that happen. There is no organization in the world, including ASA, that can come to all 585 cities in California and make this happen. There's no lawyer that has a magic bullet in court that's going to do it. There's no consulting, campaign manager, or anyone else who can take this responsibility. If your city and your county do not allow for medical cannabis activity, you have to fix that problem. And here's my promise from ASA. We will do everything we can do to help you do it, but you have to do it. No one will do it for you. And so I want to encourage you to look at our Local Access Project. You'll find it in some of the links on the Google Plus page and on the YouTube page. Look at my blog. You'll find a link to the Local Access Project in my blog. You can look at that. We'd like your feedback on it, and there'll be more and more content there this fall leading up to our big campaign starting in 2016 to adopt ordinances at the local level that allow for commercial medical cannabis activity. So I'm really excited about that because it's sort of the whole thing coming full circle. You know, in 2003, when the state legislature adopted the Medical Marijuana Program Act, or SB 420, that was as far as we could go in the state legislature. We just didn't have the votes and the political will to go any further, and it left so many questions unanswered, and the battle line shifted back to the cities and counties. And then in the last 2 or 3 years, the battle line shifted back to Sacramento. We got as much as we could get this year in Sacramento, and now the thing comes full circle, and it goes back to the cities and the counties, which is really typical of California politics. And so I want to encourage people to use the Local Access Project, use our Medical Marijuana Online Advocates Training Center, and do the work that needs to be done in your city or county to regulate medical cannabis. Now, I want to wrap up here pretty quickly, so I'm going to move quickly through the rest of the topics because I want to leave time for questions and comments from the base. So if you have a question or comment, this might be a good time to start typing that in. And please excuse me, this is a lot of typing. So let's talk about needed improvements, because the MMRSA is a bill built on compromise, and like all compromise, it is imperfect. And there are things we didn't get. There are things we didn't get everything we wanted to, and there are many, many things that need to be changed in the bill. Fortunately, we have 2 years to work on that. And so I am already talking to lawmakers in Sacramento about the changes I would like to see, and I would like to hear from you the changes that you would like to see. I'm going to talk about 3 of them very quickly. And one is this stupid provision for a 100 square foot limit on individual patient cultivation in the state of California. And people ask me after the bill passed, Don, why would you support a limit on patient cultivation? And the answer is, I did not, ASA did not, and in fact, no one knew that was coming. Well, no one outside the author's office knew that was coming. These bills, as you recall, went through a bizarre and not terribly transparent process of vetting and revision right up into the final hours of legislative session. And after legislative offices closed on the last day of the session, we got the final language, and it had this crazy provision for a 100 square foot limit on patient cultivation. The bill says that any patient who's cultivating 100 square feet or less of marijuana will not be subject to licensing and regulation. That is not acceptable. We simply do not accept it. And so we never saw this. This provision was never vetted through a policy committee, which is the usual way that bills are vetted in our state legislature. It didn't go to any committee to be debated in public. It wasn't subject to public comments. It was a really surprise to us, and a disappointing one. And while I want to reiterate here, I am very grateful to the authors for their work on this, and to the other advocates and stakeholders for the compromises they made. This provision may not stand in California because Proposition 215 did not limit patients to 100 square feet of cultivation. Patients in California are entitled to cultivate as much medicine as they want, and the very first thing on my fix-it list for next year is to repeal the provision of California law that limits patients to 100 square feet. If you are an individual patient, you should be allowed, or a caregiver, you should be allowed to cultivate as much marijuana as you need for your personal medical need. And believe me, ASA is going back to the ring with the gloves off next year to repeal the MMRSA. It may or may not actually be necessary, because I know a lot of people are planning to sue already over this 100 square foot provision. And if they do sue, and if the court process moves more quickly than the legislative process, they'll probably win, because under a Supreme Court decision called People versus Kelly in California, the California Supreme Court held that you cannot put numeric restrictions on medical cannabis in California. Under People versus Kelly, the state legislature was prohibited from restricting the amount of cannabis a patient can have and the number of plants they can cultivate. So why in the world would the Supreme Court allow the state legislature to restrict the square footage that a legal patient or their primary caregiver could cultivate? And so I hope lawmakers will look at the People versus Kelly decision, look at the process that led to this unfortunate provision in state law, and just voluntarily repeal this from the law and take us back to our constitutionally sound standards that patients can cultivate what they need in California. So we're very committed to that and look for much more action on that. Very briefly, because I see we're coming into questions now, there is a lack of protection in these laws for the non-commercial group cultivation of cannabis. We advocated very hard for a provision that would have allowed any size of a group garden to cultivate cannabis, so long as they're not selling it. It's not in the law, but we're still fighting for it. And notice I am specifically avoiding the word cooperative and collective. That old model under SB 420, the Medical Marijuana Program Act, is repealed by this because we don't need it for commercial medical cannabis activity, but we do need a protection for people who aren't in the business of selling or growing medical cannabis, but still grow it with more than 5 people in one location. And so that's an important provision we're fighting for. We'd also like to see a greater degree of vertical integration in the industry. This sounds like a strange patient perspective, but vertical integration ensures economy of scale, and it also preserves in California the existing patient cultivation cooperatives and collectives. And so we want to make sure that anywhere that vertical integration makes sense in the medical cannabis industry, we have it. And I want to be clear that we're not advocating for giant Walmart-style marijuana businesses. What we want to ensure is that one licensee in the state of California can grow, manufacture, and dispense cannabis where that's appropriate. That does not create chains or giant monopolies. It just ensures quality control, economy of scale within that closed segment. They're using a model very similar to this in Colorado already, and it has not led to giant monopolies and Walmarts and what have you dominating the industry. It's just allowed for a type of integration that makes sense in a business sense, and that's important for patients because patients deserve an efficient and cost-effective industry. And so if you're worried about the cost associated with regulating medical cannabis in California, you should be supporting vertical integration. And ASA is also asking lawmakers to allow for more leeway under regulations for the vertical integration, which was already supposed to be allowed under California law under SB 420. So those are some of the things we're looking for. There's more, and I want to encourage you to send me your comments about that. Now, before we talk about legislation and next year, and I really want to get to that, but I want to take your questions because they're scrolling over that tiny box in my screen. So I'm going to take a couple of questions, and when we get a gap in that, we're going to come back and talk about next year, and we're also going to talk about legalization. So let me take a couple of comments. The first comment that scrolled up here said, who's going to regulate the prices that cultivators are given for the product? And that is a very good and an insightful question, because in other markets, the distributors regulate that. When it comes to tobacco, tobacco distributors dictate a price to cultivators and to the retailers who provide that product. Not so in this bill. In this bill, while the distributors fulfill the bureaucratic need for counting and taxing cannabis, individual cultivators who are licensed are allowed to contract with manufacturers and retailers at a certain price for a certain quantity. And so the distributors cannot hold a stranglehold on the marketplace the way they do with alcohol and tobacco. So while that's an imperfect solution, it definitely puts the medical cannabis cultivators, manufacturers, and retailers on a more even footing in that they get to negotiate with one another without the distributor interfering in that relationship. So cannabis still has to go from a cultivator to a distributor and then to a manufacturer or retailer, but the manufacturer does not get to dictate the terms of that transaction. Number 2 here, we see, are these bills technically silent on the requirement of any licensee to be a nonprofit or a for-profit? I know the collective are sunsetted, but are the dispensaries required to be for-profit? Great question again. And boy, I'm going to be honest with you, I'm a little bit undecided on this topic because everything about the MMRSA anticipates a for-profit commercial medical cannabis industry. However, the bills do not specifically repeal 11362.765, which is the provision of the Medical Marijuana Program Act, or SB 420, which says that nothing in this act shall be construed as to authorize the cultivation of marijuana for profit. That provision has been widely interpreted to mean that all medical cannabis cultivation and distribution through the collective and cooperative model has to be on a nonprofit basis. If you subscribe to the theory that all of distribution is currently required to be nonprofit, then you could argue that the MMRSA does not change that. I would suggest 2 things to you in a contrast to that. One is this: the MMRSA specifically reads like a for-profit bill. They even use the word commercial. And so I believe it was the intent of the authors to create a for-profit commercial industry to supply medical cannabis in California. Secondly, subsection 675 does not ban for-profit cultivation. It simply does not authorize it. And if that seems like a little bit of legalese and a trick of the language, it is. And that's how lawyers interpret things like this. But many lawyers say in California that 765 does not require nonprofit operation. It simply fails to authorize for-profit authorization for political reasons. And Senator John Vasconcellos, former Senator John Vasconcellos, who authored SB 420, the Medical Marijuana Medical Marijuana Act, adheres to that position. He said he never intended with that act to ban for-profit operations, simply not to authorize them for political purposes. So someone is going to sort that out in court. However, I would say this: if we do still have in California a nonprofit medical cannabis industry, that's okay. There are some limitations on the nonprofit industry. They can't, for instance, take advantage of capital markets to fund and improve their businesses. However, an individual patient who needs cannabis to treat a serious medical condition is not any better served by a for-profit healthcare service than they are by a nonprofit healthcare service. So from a patient's perspective, it may not ultimately matter whether or not our system in California is for-profit or nonprofit. But I think when the dust settles, we're going to see that what we have now in California is essentially a for-profit healthcare system. And I think that's got some practical advantages for patients. Number 3, will this allow businesses to become for-profit? I think we've already spoke to this. And when will that go into effect? And I would say that would go into effect on January 1st, although this bill slowly stair steps into effect. And so the licensing provisions will not be until 2018. And it does not reverse any local ordinance that requires nonprofit operation. So if you're in a city like Berkeley, West Hollywood, Palm Springs, and others that requires nonprofit operation, you're still bound by the mandates of your local ordinance. Next, what if the city permits medical marijuana, but their county bans it? Another good question. You guys are on it tonight. Very well. Well done. The city or the county has jurisdiction within its borders. And so a city sets the laws within the city limits. So if you're, say, in the city of Oakland, then the City Council of Oakland will decide whether or not they license, permit, or authorize medical cannabis, and they already do. But outside the city of Oakland is the county of Alameda. And the county of Alameda has jurisdiction to set the rules for any place that is inside the county of Alameda, but outside of in the city limits of any city. So outside of Oakland, outside of Hayward, outside of Fremont. There's still areas that aren't part of any city, but are inside a county. The county has jurisdictions in those areas. So on a statewide level, that's a lot of areas, but the more urban your area is, the more likely you are to be governed by a city council and not by a county board of supervisors. But it's important to remember that it is either your city or your county that regulates land use and permitting and licensing for medical cannabis, not both. Now, one unusual proviso of this is that the bills do allow, or I should say, should preserve the right of counties to tax medical cannabis activity, even if it's occurring inside city limits. And so that's not terribly fair, but it's also a provision that an authority that counties already had in California. And so I don't like that, because that means a county could ban medical cannabis activity and still tax it in the cities that allow it. For instance, in Los Angeles County, medical cannabis dispensaries are banned. But in the city of West Hollywood, they're licensed and permitted. The County of Los Angeles has the authority under existing state law and the MMRSA to tax the dispensaries in West Hollywood. And that's legal and that's normal. That already existed in the state of California, but it sure is counterintuitive. And I wish they had done otherwise, and lawmakers did not. Another comment that popped up here. When will the protections of this law go into effect pertaining to a defense in court substantiated by a matter of law? January 1st is the answer to that question. I think what the person who asked this question is asking is, when do people in the industry, officers, directors, employees of licensed medical marijuana facilities have protection? And I would say the answer is January 1st, Although I want to qualify that answer to say I would need to look back at the 61 plus pages of language to double check whether or not that local and state license both need to be in effect for the legal protections to take effect. But my answer on first blush is right away on January 1st, your activity is legal. And if there's anyone who's watching right now who has a different answer to that question, I hope you'll chime in, because that is actually not something I researched before this broadcast. So I see right now there are no additional comments popping up. So I'm going to move forward with the last couple of topics on our agenda. We've got about 11 more minutes, but keep sending in your questions. These are great questions, and I want to get as many of your questions or comments as possible. We already talked a little bit about fix-it legislation. That is this 100 square foot limitation, the non-commercial group grows, the lack of vertical integration. These are all things that we're going to go back to authors next year and talk to them about what needs to be fixed. But we're also going to do is we're going to go back and talk to authors about protecting the rights of medical cannabis patients in California, because Proposition 215 gave you a defense in court, SB 420 defined the parameters, and this bill protects people in the industry from criminal prosecution, but it doesn't really protect anybody from civil prosecution. And I get calls every single week from people who are facing discrimination based on legal medical cannabis use. It's discrimination in employment, housing, parental rights, and access to healthcare, including organ transplants. We scored a huge victory this year when we passed AB 258, the Medical Cannabis Organ Transplant Act. But we also hear people who are being discriminated in their prescription drugs. They can't get their pain medicine. That's a top priority. And next week, I'm going to be back in legislative offices talking to lawmakers about protecting patients who need opiate medicines to treat pain and are also lawfully using medical cannabis. I also have a really exciting appointment next week to talk about employment discrimination in California, a battle we've been fighting since 2008. We are not leaving that alone. I look at the advent of commercial regulations as an opportunity to turn our focus and our priority back to patients' rights in California. I see a few more questions popped up. I'm going to go back to those before we get to legalization in the next 9 minutes or so. This one says, the term volatile solvent manufacturer is too vague. Will the legislation include a black and white definition of this? And the answer is no, but the regulators will. The regulators charged, the Bureau charged with regulating this, should come up with a volatile solvent manufacturer. For those of you who aren't familiar with that conversation, what lawmakers mean when they say a volatile solvent is butane. As you know, there have been many people who are making butane extracts, which many patients rely on, and they cause fires and they blow up and people are injured and property is damaged. And there were several attempts to address that in legislation this year in California. I'm not going to get into those bills for time's sake, except to say that the proper way to deal with this is to look at science and occupational safety regulations and deal with it through the existing regulatory model. We do not need standalone penalty enhancement bills in California to deal with butane extracts. I also want to say to people that you need to be reasonable about this, because there are many things that you're allowed to do in your home, like brew beer, grow tomatoes, manufacture wine, as long as it's not a part of the commercial enterprise. If you sell your home tomatoes, you have to get a license. However, volatile extracts like butane do explode, and safety regulations are important. And first of all, I want to say, if you're doing that, be careful. Please be careful. Don't injure yourself in order to make medicine. And then secondly, consider your neighbors and your cohabitants in your house and the people nearby, because there are explosions. And this may be a place where we need safety regulations on a state level to prevent accidents and tragedies. And so, yes, the question is correct. We do need a better definition of volatile solvent manufacturer, and that falls to regulators to do it. Okay, next question. A nonprofit collective was raided in Ojai, I think I'm pronouncing that correctly, this week by the county sheriff's office. No charges have been filed, and they won't release the search warrant until they are required to. That's typical. Are there other reports of law enforcement trying to take a last few swings at cannabis operators before the rules go into effect? And I have to say, while that is probably happening, I don't have a lot of reports of it. I think Ojai up in Ventura County, is that right? And that's one of the areas in the state where law enforcement's been very reluctant to embrace medical cannabis and regulations. And I think we're going to still see, before the regulations take effect, some enforcement. We're also going to see it after regulations take effect. And the great news about the Medical Marijuana Regulation and Safety Act for the victims of inappropriate and overzealous law enforcement activity is that you will have protection under state law that is explicit, a section of code you can cite to be acquitted and have charges dropped, as opposed to a philosophical and legal rationalization that you have to bring up in a hearing to persuade the judge you shouldn't be prosecuted. So I'm sorry to hear about this situation. OGI, email me more information if it's something with which we can be helpful. Don@safeaccessnow.org. Don@safeaccessnow.org, and we'll look into it. But you know, some law enforcement have come to the table to negotiate in good faith, and some have not. So we're still going to keep fighting that fight in California, probably for several years after regulations. The good news is that in states where they have regulations, that activity is dramatically diminished. Someone else said, just wanted to say thanks, Don. That's nice. Thank you. You're welcome. So while we're waiting for any last comments, I want to speak briefly to the issue of legalization. And this issue is so complicated. And the first thing I want you to know is that the wheel is still in spinning. It's all still in play about legalization. We don't know what's going to be on the ballot, if anything, in 2016. And I want to caution everyone who believes in the cause of legalization not to be suckered into the mythology of inevitability, because nothing is inevitable. We still have to go out and gather signatures, raise money, and vote on a voter initiative to get this adopted. And so the first thing I want to say about legalization of medical cannabis is that I'm very encouraged by what I've seen in the drafts that are either pending circulation or being circulated, and that none of them try to step on medical cannabis patients in order to create a legal industry for cannabis, for adult use of cannabis in California. That is awesome. And I want to thank the authors and the proponents of those initiatives for not using patients as a stepping stone to legalization, because that's not how I see medical cannabis. It's not how ASA sees it. And I don't think it's how patients in California see medical cannabis. And so I think that that is a really important testament to the goodwill of the community in California. I also want to say, in terms of evaluating the initiatives, that what I'm looking at for initiatives in 2016 is a patient-first perspective. We should not, I say we in that royal sense, patients in California should not give up 1 inch of the territory we fought so hard for over the last 19 years in order to facilitate the creation of an industry for adult use cannabis. So patient cultivation, patient rights, other provisions related to the individual activity of patients and their caregivers, we shouldn't have to yield any ground there in order to create an industry, and we don't have to. We can see in other states, for instance, in Washington, patients had to give up cultivation and tax benefits and what have you, and in Colorado, they did not. What we have to realize is you do not have to give up patients' rights to create an industry and to protect rank and file Californians who use cannabis for non-medical purposes. So let's don't do it. Let's don't support initiatives that require patients to give anything up. I also want to say, before I get back to questions, I know they're rolling in, and wrap this up, that an initiative that's going to succeed in California and hopefully protect patients and build on Proposition 215 will be pragmatic, and it will be fundable. And when I say pragmatic, what I mean is that it has to appeal to 50% plus one of voters. And if you're watching this broadcast right now, you are probably not part of the majority. You are probably really enthusiastic about cannabis and medical cannabis. You love it, it's important to you, and your views do not reflect the majority of Californians who are indifferent, ambivalent, or mildly supportive of medical cannabis. And so don't think that because opinion polls show most people favor legalization, that they will line up behind any voter initiative. In fact, that voter initiative is going to have to toe a middle line, and it won't give us everything we want, because we need to get majority support. And so nothing will pass if we go way out in left field and demand everything in legalization. So be reasonable and pragmatic in what it is you want to see on the ballot. It also has to be fundable. And what I mean by that is that it's expensive in California to get a voter initiative and so on the ballot and approved and fight a campaign. And so you're going to have to be able to show funders to do that you can win. that you're pragmatic, that you can draw a majority of support. And that's really important because you're not going to help patients in 2016 and non-patient users by putting an idealistic voter initiative on the ballot and losing. And in fact, that would be a terrible setback as far as the political perspective and perception of medical cannabis in California goes. And so I know there's a big debate in our community about cannabis and medical cannabis and legalization. ASA has taken no position on any initiative, but I want everyone to remember these three things: patients first, be pragmatic, and make sure it's fundable, because it's going to take a lot of money to get it done. So that's my little legalization thing. We're going to do another broadcast, I think, on legalization because it's such a big, big topic. But I want to get back to questions because we're running out of time soon. By the way, we're going to run a little bit over. It's less than 1 minute till 9. Stick with me if you can stand it. Let's see. Is there a way to manufacture now that it's compliant with state law, such as non-volatile solvents? Would one have to wait until January to manufacture legally? And the answer is no. There's no law prohibiting the manufacture of concentrated cannabis right now. However, you need to get busy getting your city or your county to license, permit, or authorize that manufacturing, because by 2018, you'll need a local license to get a state license. But as of now, no, nothing has been prohibited. Next, let's see. Is it possible to obtain a license before the law comes into effect? Good question. Or is January 1st, 2018 when we can apply? And the answer to both those questions is no. On January 1st of 2018, the Bureau is created, but the governor will still have to name a director. Other state agencies and officials will have to name people to the Bureau. They're going to have to buy computers and desks and chairs and paper for the printers and printers. There's going to be a long time before regulations are issued and license applications are available. 2018 is a deadline. If they really get on it, they could do it fast. But I want you to count on a year to 18 months before applications are available, because state bureaucracies go slow. And so the good news is if you're not ready, you've got some time. And the bad news is if you're ready, keep waiting, because it's going to take a minute to get these licenses issued. Next down, let's see. My attorney said that any board members with a prior felony will be disqualified in application for a license, but it looks like it got struck in the last version of the bill. Could you elaborate, please? And thank you for the great info. Well, you're very welcome. And yes, this felony thing was one of the issues we went right down to the wire on. And in fact, the governor had to intervene at the last minute to make sure we had an agreement. Law enforcement sought to restrict all people with felony convictions from participating in the industry. Industry tried to get this thing completely waived and say it's not a problem, and we met in the middle. There are some drug-related crimes and some crimes of moral turpitude around fraud and deception that disqualify you from a license. And there are other cannabis-related crimes where the Bureau is going to have some discretion. These provisions are extremely complicated. My head spins when I read them. And so the simple answer to that question is that if you've been convicted of embezzlement or fraud or what have you, you're probably out. If you have been convicted in California of trafficking in other drugs besides cannabis, you're probably out. And if you have any other felony conviction, you should get a lawyer and talk to them about how you qualify under those regulations, because it is complicated and you have to look at very specific code sections to determine whether or not you're excluded. There is, however, an out. There are two safety valves in this provision, and one is what's called a certificate of rehabilitation. If your conviction is a certain number of years in the past and you can persuade a judge that you have been rehabilitated, then of course they can issue the certificate, which doesn't eliminate your felony conviction but makes it irrelevant for purposes of licensing. And the other is expungement. There's a process called expungement where you can go to the courts and say, I want my record wiped clean. It's hard to get, but if you get that, then of course it would not apply. These are not great provisions, but I want to say a very special thank you to the NAACP and the ACLU, who stepped up at the last minute and really pushed back to defend the rights of felons, people who have felony convictions, to participate in the industry and have a fair shake at that, because many good people have felony convictions over cannabis because they were trying to do right and they just got convicted in the days before everything was clear or legal. So I'm encouraged by that, but that issue is not 100% fixed because the Bureau is going to have some discretion. So again, if you have a felony conviction, please go and see your lawyer and look at those specific code sections to see how they apply to you. One more question popped up. It's 9:04, by the way, Pacific, so we're going to wrap up pretty quickly. If you have another question, type it right now. Get busy. Don't worry about punctuation. Get it out there. So finally, it says, is this the right place to put a question? Yes, I will answer that right away. Is there a way to manufacture now that they're compliant with state law? I think we already did this one. And the answer, of course, is yes, you can still compliant. You have until, you should still manufacture, rather. You have until January of 2018 to get both your state and your local license to manufacture concentrates. That's a bit of a battle, by the way. Don't wait, because I don't know of any state, any city or county that currently authorizes or permits or licenses manufacturing concentrates. So get on that. Now, as of right now, I do not see any questions popping up. You've got about 30 to 45 more seconds to get them in there, because I'm going to wrap this up really quick. We try to keep these at about an hour. So first of all, thank you for joining me tonight. I know this is a lot of talking and a lot to soak in. I want to encourage you to look at the comment sections where you'll see some links that I put up to blogs, to a really great report by attorney Steve LaBelle from Los Angeles about the Medical Marijuana Regulation and Safety Act, and to some other resources that you can find. If you did not get an email announcing this live Google Hangout, you should get on our mailing list. Go to americansforsafeaccess.org or safeaccessnow.org and get on that mailing list, so you get my California Weekly Roundup that has all the news and events from around the state of California. I also want to encourage you to get on the California Campaign for Safe Access email discussion list, so that you can talk amongst yourself about medical cannabis activity. You can find that also on our webpage, on the California Campaign for Safe Access. And if you're a medical cannabis provider, we also have a list just for providers, a private list that you'll also find on our website, ASA Providers, for medical cannabis providers in the state of California. So we have tons of resources. I also want you to check out the Local Access Project for the resources we have there right now for local advocates to get busy with the work of adopting ordinances at the city or county level that license, permit, or authorize commercial medical cannabis activity. And I want to reiterate that ASA is here to help you, not to do the work for you, but to help you do this work in your community. And I promise you, the advocacy of local people like you matters way more than the opinions of people like me coming from out of town to do this work. And the same thing applies to lawyers, lobbyists, consultants, and the whole range of people who might help you. You are the most important thing in your local campaign. So I see no new questions popping up, so I want to say thank you again. We're going to wrap up here. We're about 6 minutes over time. I hope you guys don't mind. Thank you for participating. Thank you for staying in touch, and get on those lists so that we can keep in touch about what's happening with medical cannabis and what's happening next year, which is really, really exciting around patients' rights. Now, having given that closing, I see a couple more questions, and I really want to encourage everyone to participate. So if you're logging off, thank you and good night, but stick around if you want to hear these last two comments. In your opinion, which business entity is best for this type of industry? Wow, good question. I am not a lawyer or an accountant, and I will not give you legal advice or accounting advice. I speak as a layman and as a veteran of the medical cannabis industry myself. I've been in the business since the year 2000. I think if you are committed to the nonprofit model and you believe that that is the proper way to do it, the California Nonprofit Mutual Benefit Corporation is a really good option. There are also consumer and cultivator cooperatives under California law that meet those nonprofit criteria. If you are committed to the for-profit model, be very careful and talk to your accountant about what's called flow-through liability. You do not want a corporate structure for which tax liability flows through to shareholders or officers or directors. That's important because federal law has not changed, and the IRS may hold a corporation liable for taxes associated with the ordinary operating expense of the business. I'm not going to get into all of that now. Talk to your attorney about it, but it's really important that you don't have a flow-through corporation structure like a subchapter S corporation where the liabilities for tax assessed under IRS Section 280E regarding medical cannabis flow through to the shareholders. You want that liability to stop with your corporation. And again, please talk to a tax attorney about that topic because it's very complicated and I'm not a professional giving you legal advice. And finally, Will this be posted on YouTube for people who missed it? Yes, all of these live broadcasts are on our YouTube channel for Americans for Safe Access, and also on the Google Plus website. You'll find them archived on our blog, americansforsafeaccess.org/blog. And of course, I will include them in the California Weekly Roundup. So there are plenty of places to find it. It's about 10 after. You guys have been great sports. It's late, and poor Talana in Washington, D.C. is up really late. Thank you, Talana, for facilitating this live Google Hangout for our members here in California. Thanks again for joining us. And I'm going to wrap it up here. Keep talking online. Keep talking on the discussion list. And I will see you guys next time on our next live Google Hangout. Thanks so much and have a great night.